welcome Sheri Abrams, an attorney at law, talking about some really good information that will help our foster, adoptive, and kinship families and families with special needs try to figure out how to best plan for the future and caring for their children as they start to enter adulthood. So I am happy to turn it over to Sheri and hear what she has to share with us.
Thank you very much. It's my pleasure to do this presentation today. Again, I'm Sheri Abrams. I'm an attorney in Fairfax County. My office is in Oakton. I've been practicing this type of law for the last 24 years. These are some of my credentials. I do Social Security disability law. I do guardianship, special needs trusts, estate planning, wills, and powers of attorney, and other types of elder law and special needs planning topics as part of my practice. I have a special needs planning guide, legal planning for children and young adults with special needs. That is available for free download at my website, sheryabrams.com. It's a good thing to take a look at. I also have a book entitled Don't Gamble with Your Social Security Disability Benefits, also available for free download. You should definitely check out my website, again, sheryabrams.com. That has a lot of information on all the different practice areas, Social Security, guardianship, special needs trusts, a lot of other things. Great resource section as well. Also have my blog, which goes through a lot of different topics that are more timely. I update that frequently. That's virginiadisabilitylawblog.com. You can also get to that through my website. I send out a free monthly newsletter electronically. You sign up at my website. That gives, again, very timely information about disability topics. And also, if you follow me on Facebook and other social media, you'll keep up to date with what is going on. So, special needs trusts. They're also known as supplemental needs trusts, but I always refer to them as special needs trusts, so that's what I'll do today. They hold and disperse assets for a disabled person. They're intended to supplement, but not be the main source of funding for someone who has a disability. They're supposed to cover things that are not covered by public benefits. The purpose is to improve the quality of a disabled person's life, to give them those extras that they deserve and they need. The other thing that is so important about a special needs trust, or SNT as we call them, is that by having money in a special needs trust, the disabled person is not disqualified from eligibility for public benefits such as supplemental security income, also known as SSI, and Medicaid, disability housing, vouchers, or Section 8 housing, or other types of public benefits. The other advantage of having a special needs trust is that the disabled person does not have access to the money directly. There is a trustee, so you don't have to worry that the disabled person is using the money inappropriately, or someone is taking advantage of them and using the money inappropriately. So therefore, it helps with the financial management of that money. So who can do or have drafted a special needs trust? Anyone who has a physical, mental, or intellectual disability as defined by the Social Security Act. And there's a million different things in there. So as far as if someone really self-identifies as disabled, or you feel they have a disability, even if they are currently working, even if they don't qualify for Social Security disability or SSI benefits, or they have tried for it and been denied, doesn't matter. You do not need to be receiving Social Security disability or SSI benefits to have a special needs trust. So there are three types of special needs trusts out there. One is a self-settled or first-party trust. You may hear that called a D4A trust. There's also a third-party special needs trust, and there's a pooled special needs trust, also referred to as a D4C trust. And those are the trusts that are handled by the ARC of Northern Virginia, which is up in the Merrifield area of Northern Virginia, and also the Commonwealth Community Trust is down in the Richmond area. Those are trusts that are handled for the person. The trustee / the grantor, or the person who handles that trust, is that organization. You would give up your right to be the trustee if you use a pooled trust. So self-settled or first-party special needs trust. That is used for the disabled person's own money. So, for example, if a disabled person receives a settlement from a lawsuit or an inheritance that is paid directly to them, we can put it into a self-settled or first-party special needs trust. However, the drawbacks to that, even though it does make the person eligible for public benefits, is that there is a payback provision in the trust that at the time of the death of the disabled person, if there is money left in that special needs trust, that money has to be paid back to Medicaid if the disabled person at any time received any Medicaid. So that's why it's very important that we try to avoid this because of that payback provision. As additional rules for a first party, that it can only be established by the disabled person themselves, the parent, grandparent, legal guardian, or the court. So, for example, a sibling couldn't establish a first party special needs trust. Also, this trust must be irrevocable, can't be changed. So that makes it much less flexible than, let's say, a third party special needs trust, which I'll talk about in a minute. It must be established, the first party trust, and funded before a disabled person turns age 65, which can be an issue if you have an older person who inherits money or gets a settlement. We have to then look at other ways possibly to keep that money, and that person may lose their eligibility for public benefits because we cannot put it into a first party special needs trust if the person's over 65. Now, there's a special type of first party special needs trust that was started by the National Defense Authorization Act of 2015. That's for anybody who gets survivor benefits from the military, also sometimes called SBP or 55%. I hear that it called that at different times. That is a retiree or active duty military can sometimes earmark that survivor benefit to their child. And if the child is disabled, the only way for them to receive this benefit from the military, the 55% survivor benefit, and keep their SSI or housing or other public benefit, we have to put that money or have it be put into a special first party special needs trust that's strictly set up in a certain way for the military. It does have a Medicaid payback provision, and it does require a special letter from the attorney and special forms, but it is a great thing that we didn't have before that would enable a child who is eligible for that retiree or active duty survivor benefit to be able to continue to get or be eligible in the future for public benefits. So the next thing I'll talk about is the type of special needs trust I do the most of, which is a third party special needs trust, meaning that this money is coming from third parties, not from the disabled person, from anyone. It could be a parent, a grandparent, a friend, a sibling, anybody can give money, aunt and uncle, so forth. There is no age restriction to establish or fund the trust, so that person can be any age. The key is that there's no payback provision to Medicaid. What happens is that if the person who is creating the trust, the grantor, for example, let's say it's a grandmother, the grandmother earmarks the money for the special needs trust, but then she in the trust indicates who she wants any remaining money left in the trust to go to when the disabled person passes away. Another grandchild, for example, or a charity. I mean, it's definitely more flexible in that regard. Also, it can be revocable, and that gives you a lot of flexibility. So, for example, if parents start funding a third-party special needs trust, and then something happens and they don't need the money anymore for the disabled child, for example, the child gets better, or perhaps the parents need the money themselves, they can revoke the trust, which they really could not do with a first party trust. Also, how I do a third-party trust in most cases is I create the trust to be a standalone or living special third-party special needs trust, meaning that it's created now in your life. Some people have had, and you want to go back and look if you've done this, a special needs trust put in their will. So it just springs into being at the time of your death. The reason I don't like to do that in most cases is because, for example, let's say you have this special needs trust in your will and grandma passes away. She can't leave that money into your special needs trust because it doesn't exist yet. So therefore, you creating a standalone living special needs trust, there's a place for other people's money to go into and contribute for the benefit of your disabled or special needs child. Now, what can a special needs trust pay for? There's pretty much anything you can think of a special needs trust can pay for. Obviously, that has to be for the benefit of the disabled person. The majority of people pay for extras for their child, things that are not covered by public benefits. Things like social events, vacations, some of the things that you see here, things that make things better. But again, there is also things that are more practical, dental care, going to the barber, that type of thing, aides and attendants, care managers, that type of thing. Now, expenses that a special needs trust should not pay for. Care should not be given directly to the disabled person for any purpose. That will violate the terms of the special needs trust and will cause it to fail. Also, food or groceries should not be used. So really, no housing or food of any kind. Restaurants are included, rent or mortgage payments, property taxes, dues for condos, utilities, so forth. Those things should not be used to be paid for by the special needs trust. However, sometimes you need to do it. That would be if you need to use money in the special needs trust to pay for room and board, for example. If that's the case, then Social Security will reduce the amount of SSI benefits by 1/3. In 2020, the maximum amount of SSI benefits is $783 a month. So the 1/3 reduction can be substantial. However, the trustee will have to determine if it is the right thing to do in the specific situation, that maybe it pays to use the money to pay room and board because that's the only way that they're able to get a suitable place for the person to live, and it's worthwhile doing that 1/3 reduction of the SSI benefits. Funding your special needs trust. To be able to fund a trust is very, very important. It doesn't help if you have nothing in your trust because you want that to go to your disabled person. So what it can hold is cash, investments, real estate, really anything that you can hold personally can go into that. Life insurance is a key to having to be able to fund a special needs trust. Life insurance, especially second to die life insurance, can be put in there to be a beneficiary of, the life insurance. The special needs trust can be the beneficiary of the life insurance that you have, so that at your death, the X number of dollars will definitely be going into the special needs trust for the benefit of your disabled child, but your child would not lose the eligibility for public benefits. Now, that brings up the point of beneficiary forms. You definitely want to make sure you have done those for life insurance and other types of investments, so it goes to the special needs trust if that's your choice. Also, a lot of people that I work for have their children, when they turn 18, apply and receive SSI, Supplemental Security Income, from the government. As I said, it's $838 a month right now. To be able to get that full amount, however, the disabled person has to pay rent to their parents, for example, if they live with the parents. Now, if they don't pay rent, they won't get the full amount. So what a lot of parents do is they take the rent, which I usually advise to be $500 a month. They take that from the disabled child, as a form of rent or room and board, and then they do anything they want with it, but they choose to swing it into their standalone third-party special needs trust. And that's a way that they fund it every month so that they can see the money starting to accumulate for the benefit of their disabled or special needs child. Things to not forget that's very important. One, in the past, without special needs trust, a lot of parents and grandparents and other people would disinherit the disabled person. This is a way for you not to do that. You want to be able to give as much as you can, possibly more than other children or grandchildren in your family because they have a disability. And there's no need to disinherit them now that a special needs trust is available, so that the child or grandchild will be able to keep the eligibility for public benefits. Also, it's important not to give assets directly to the disabled person in your will or so forth, because again, that will force us to have to do a first-party trust or some other type of mechanism that we would use so that the person would not lose their eligibility, but then you'd have the payback to Medicaid. Also, if you do a special needs trust, make sure you have a will drawn up so that it pours over into the special needs trust. Things that don't have beneficiary forms, you want to make sure if it's your wish, it goes into the special needs trust. You want to update those beneficiary forms on your 401k and your any kind of investment so that if you want it to go to the special needs trust, it does say that. You want to ask everyone and anyone to contribute to your special needs trust in their legal documents. Make sure you tell family members that if you're going to be giving money to our child, we really need to do it in this way with this title, the special needs trust. To ask others to contribute is very, very important because it will get a lot of money to your special needs trust that maybe you didn't consider having done. Also, you want to write a letter of intent or a memorandum of intent, because then it will be a mechanism for you to be able to tell the trustee what you want the money to be used for, and also special things about your disabled child. For example, they don't like broccoli, for example. Myself and other attorneys give guides to how to write a memorandum of intent when you sign the special needs trust. This is my information, where my office is, and my website and my email and phone number. Please feel free to contact me if you have any questions about this presentation or anything else having to do with special needs planning or Social Security benefits or SSI benefits, guardianships, anything to do with wills, powers of attorney. Be happy to answer your questions. These days we're somewhat sequestered because of the pandemic, but we are available to answer questions. We just have you give us a call, send us an email, and we'll be happy to do it. Thank you so much.
Thank you, Sheri, for that great presentation. It was filled with a lot of really good information to help guide the families, and we appreciate your time and sharing all of this with us. And we look forward to hearing from you in the future. So thank you for your time.
Very welcome.